Commission. Sorry for the delay, but we did have a software issue, so hopefully that's taken care of now. So I'll call the meeting to order. Roll call.
Adams.
Here.
Bruce.
Here.
Harp.
Here.
Paniro. Here. Paulson.
Here.
Sonnentag.
Here.
And Summers is absent and excused.
Okay. First item on our agenda is the Plan Commission meeting minutes of September 24th. And
Move
there-
approval. We don't need a motion.
Don't.
There we go.
You're okay? No changes? Okay. I'll declare the minutes approved. And let's see, what do we got for?
You go back to the agenda, Daphne.
Here is it.
It's this item.
All right, item 1 on the agenda is the resolution 2024 to approve a conditional use permit for a medical clinic and ambulatory surgery center at 8124 Forsythia Street.
Yes, and following the public hearing at your last meeting, I drafted the findings of fact based on the hearing evidence that was presented, as well as the Plan Commission comments and discussion. And our recommendation is to approve resolution 2024-48.
Discussion? Motions?
I move approval of resolution 2024-48.
Is there a second?
Adams, a second.
It's been moved and seconded. Any discussion? Hearing none, I'll call the question. All in favor?
Aye.
Opposed? Motion carries. Okay. Item 2 on our agenda is a certified survey map for 4-lot subdivision at 2159 Allen Boulevard. And you're gonna kind of lead us into this, Abby? You and Mark?
I got it. Yeah.
Okay.
And actually with our glitches, Daphne, did you get the PowerPoint? Were we able to open it?
Yeah.
Okay, good. So I put together a few slides, which Daphne's loading. This pertains to a 7.1 acre site on Allen Boulevard, bounded by Allen Boulevard, Marshall Park, Mendota, and Middleton Beach Road. And we have some revised staff recommendations. And I'd like to go through those quickly since there was some email traffic on this and I wanted to clarify some things. Next slide, please. So the first issue is the contingency number 2, which relates to the sanitary sewer network. Just for context, the network you can see on the screen here at right, green is the city sewer mains. The gravity flow runs north along underneath Middleton Beach Road properties to a pump station and then gets pumped back via force main to Marshall Park, where it runs into the Madison Metropolitan Sewage District. To the west of Allen Boulevard is also an MMSD collector run. And it's their policy that individual private laterals can't connect to MMSD collectors. They want to see it connect to a municipal or a city main. So that's just some context for you here. Next slide, please. Middleton Beach Road has a lot of issues with connecting to Middleton Beach Road, potential issues. This is from 1940 is when the iron pipe was installed. Next slide, please. And so the reason it's difficult is because aside from the age, it's in an environment where it's likely to be sitting in groundwater. An iron pipe in groundwater could have contact with reactive soils. The pipe is also at a shallow depth, which means that the laterals to each residence have little pitch, and any sort of problems with the pipe could lead to backups in houses. So that's one of the concerns we have as well. Because they're located through many of the lots, most of the lots have the sewer main running through the lot. It's difficult for our maintenance equipment to access them for maintenance. And the last issue is the pump station, which is in the photo at right, is also small and likely lacks capacity for significant increase in flow. So that's the issue with the sewer main along Middleton Beach Road. Next slide, please.
Mark,
Yep.
Yeah, go ahead.
Can I ask a question? So this road was redone 2 years ago?
Yeah.
Why was the 1940 iron pipe not?
If you can go back to one more slide too, please. So, yeah, that one's perfect. So usually the sewer main is underneath the road. It's not.
Okay.
It's in the houses.
It's
or in the
underneath,
yards.
yeah. And so for years and years, the city would like to see it beneath the road, but it's hard to get everyone on board with that plan and the relocation costs and the impacts. So it was not something that we felt should be pursued because
Hello?
Getting everyone on board means having the residents agree?
I can't speak to all the issues involved with the discussions with our public works staff, but my understanding is that to relocate a sewer creates significant disruption for individual connections to each lateral. And so, yes, there would have had to have been that and the cost to relocate it.
Okay, thank you.
Can you go up one slide, actually? So
Go back one
go
more.
back one slide, yeah. So the reason this is a concern is that the parcel we're looking at is 2159,
Right.
and you can't connect east. That's what you're saying. You can't connect
Well,
east to that.
We, there's a lot of problems with that. We
Okay.
can't, we're not
And
completely.
you can't connect west underneath the boulevard because that's an MMSD collector.
Unless we put in a parallel city main. That could be done too, to put in a parallel city main. I'm getting.
Sorry, you
That's all
keep
right.
going.
And this just shows the proximity to the two sewer mains, the city-owned sewer mains, one of which is in Marshall Park at the bottom left. And that is, what you don't see there is that the force main from Middleton Beach Road is coming to that point as well, but that's the nearest place to connect. Again, in Marshall Park, which is why the contingency originally talked about getting Madison permission and to grant an easement to connect to that location. And then the other one to the east that serves Middleton Beach Road is actually located on private property, not even in the road. So getting access to that was problematic. And then all the reasons I mentioned earlier that has potential problems. So that means our condition, next slide, please. We're recommending revised contingency for several reasons. One of which the developer asked that we not tie this directly to a solution with the city of Madison, which doesn't mean they can't get their cooperation. That's not the issue, but just to be tied into that specific language. So in talking with our city engineer, who was out last week when we developed the staff recommendation, he had some additional language that he wanted to see to protect the city's interests as well as our city attorney's feedback. So the revised contingency number 2 is shown on the screen. Basically what it says is that the developer would pay for the cities to study the water and sanitary sewer infrastructure. Our city engineer thinks that study would be in the low 10,000s. That's why we suggested a number of 25,000 to be held in escrow. Pending the outcome of this study, the developer would secure approvals and easements if necessary and to construct the public and private utility improvements needed to serve the planned development. This was actually a comment that was initially that was in the staff comments in July for the concept that was reviewed in July. So this study is not a new idea. Next slide, please. Contingency number 4, we're also recommending a minor revision, adding the words "and the stormwater management agreement recorded for all 4 lots." That was a request from our city, or our suggestion from our city attorney. And then the last issue I wanted to touch on is site access. I know that that's been something that we've talked about at the commission here for a couple of meetings. And it's also a concern the developer has. I wanted to provide some background. So as you all know, Allen Boulevard is a 4-lane median divided arterial. It's known as County Trunk Highway Q. Developers proposing access via Allen future to serve lot 2 and 1 via Allen Boulevard. As well as shared access via the green arrow at Mendota Avenue, but is not proposing driveways along Middleton Beach Road. Access control is regulated by our subdivision ordinance, currently section 19.074G. Also, our new zoning ordinance has at section 10.0603 has vehicle access standards that reference the subdivision ordinance and the city's access management plan. So those are the three areas we turn to for guidance. I'll just highlight a couple things from that on the next slide, please. So from our access management plan adopted in the mid 2000s, these are excerpts from that. Each driveway should be located based on proximity to adjacent driveways on opposite sides of the street. And if the street is median divided, it's proximity to a median opening. And so as you can see on the right, I drew a line that measured it to be about 316 feet between the crosswalks. The concern that our city engineering staff have, which is understandable, it's also based on recent experience with a project on Parmenter at the Trotta, for example. There's been some U-turn movements there with people trying to get to the driveways that's causing some conflict points. So we have plenty of evidence of why this is an issue, why these policies exist in our access management plan. I don't want to go into all the numbers here, but just to point out that we have documentation and a basis for why we are including the contingency that's in contingency number 4. Next slide, and the last one, sorry, was on the bullet here. Median divided streets driveway should be located to align with the planned median openings or sufficiently located away from the median opening. And that's really the big one here. Next one. This is looking north along Allen Boulevard, and then the other view, the other direction looking south. That's the existing median break at Lakeview Boulevard. The access point looking north would be just a bit beyond the fire hydrant, but at this point, we don't know what that future development will be. We've seen some initial concepts over the last year, but that's not before us tonight. What's before us is the CSM. So what we are concerned about is making sure that we preserve, next slide, preserve our access so that, and what our engineering staff is recommending is that there be language in the approval of the CSM that restricts access along Allen Boulevard to the yellow, where the shifted location is for the yellow driveway opening would be at Lakeview Boulevard. And so that's the recommended language with no change to it. And I guess that's my background.
Yes.
May I just comment on the rationale on this page? It says driveway at Lakeview Boulevard median break was discussed by Plan Commission twice previously in July of both 23 and 24. At the July 2024 meeting, Commissioner Summers and I both suggested that instead of having the driveway access at the point shown in yellow on the map, we thought a right turn in, right turn out, not aligned with the median opening would be suitable.
And I find that somewhat persuasive too, but in talking with our engineers, that's when they pointed out the Trotta example. So we have a right in, right out there, but what's happening is drivers will pull out of the Trotta and then go against traffic to get to the median opening.
Sure, but if you look at this map, anybody who's headed to those apartments coming from the north, as long as there is driveway access on Mendota, there's no reason for them to do that. I think the problem with the Trotta isn't the problem that there's no
That's
other.
fair.
There's
There's
no
no other
cross
opening.
easement.
No, it's a
Yeah.
fair point. That's a good point.
Yeah, but.
Can we go back to that image,
Yeah.
Daphne? I'm sorry.
Lisa, I think in fairness, there was multiple views regarding the.
Oh,
ad
sure.
access
No,
point.
no,
Yeah,
no. Right. Thank you. I just wanted to make it clear that it sounds like by saying rationale, it sounds like there was agreement on the Plan Commission that this was the way to go. And I just wanted to note that at least two of us thought otherwise.
That's
Yes,
fair.
Go ahead.
I was just gonna mention in that discussion, one of the things that we talked about is that there would be a traffic study that would be required and we would look at that access point. And we worked with the developer on that and we're open to the idea of doing a traffic study for the entirety, all 4 buildings, but because they didn't know with certainty what their plans were for the west side, they said, no, we don't want to do the full traffic study right now. So what we're proposing would be to protect the city's interest for access control on Allen Boulevard, but it would not necessarily preclude something changing in the future. But at that point in time, we would have a study and we would understand what the impacts are.
But perhaps the study should be referenced in the contingency instead of you know, instead of specifying a particular option, perhaps the driveway access along Allen Boulevard shall be determined based on a TIA.
And the reason that the language is specified as it is because it's consistent with the city's traffic control policy. So that's why we chose what we did. And I think the CSM is the time for us to put those kinds of restrictions in place so that we can make sure that we have leverage to get it studied at a later date.
Yes.
So usually when we approve a CSM, we're thinking that each parcel has its own access to the street. But in this case, we're talking one access for two parcels. So there'd have to be some cross easements recorded. And so I'm a little concerned when I see that we want to create a parcel line deliberately in a place that's different than where we are expecting the driveway to be. Because usually if you're going to create two parcels, you're going to have a driveway that is half on each. But this, right, I mean, if you overlay the proposed CSM, can you go up to slide 8? Daphne?
Slide 8, Daphne.
There we go. Right, you see that in between of lot 1 and lot 2 is not lined up with the Lakeview Boulevard. So that makes me confuzzled because I'm not sure which is the right way to think about it. But if lot 1 and lot 2 are gonna, at least in the concept plan, had two similar sized buildings, you'd have to make them about equal size.
Kurt, I understand your point. Intuitively, it makes sense for the lot line to kind of straddle the access point. But the cross access, they're going to have to have cross access easements anyways. Where the lot line goes really won't matter if that easement agreement is properly drafted.
Right.
It matters from the standpoint of setbacks, impervious surface ratios, things like that.
Yeah, but not in terms of access itself, where the pavement is.
I mean, so it raises a larger question, which is if lot 1 and lot 2, at least in the concept plan, are shown as kind of at the same time, similar sized buildings, why do we need two lots? Why not one lot with a conditional use for two buildings or even a PUD that would solve the traffic issue? I don't know. I'm trying to figure this out.
All we can do is deal with, I mean, we have a CSM that's been provided to us and we have until October 28th, I think it was, to take action on it. And so all we have right now is the 4 lots that conform to our zoning standards for each of those lots. We do not have a development proposal for lots 1 and 2. We do have one for 3 and 4.
But approving a CSM kind of locks us into certain site plans that are feasible and some that are not.
Presumably they would not submit a CSM that would render something that they're considering unfeasible.
Right. And the city should not approve a CSM that renders.
Right.
Yeah. So the staff recommendation then is to, I guess, to Lisa's point, would it be consistent with your understanding that we could condition this on a traffic impact study and then I'm not sure what we'd say, because we have to ensure a cross-access easement. Because we will only allow one driveway, right? On Allen?
Off Allen, yeah.
Off Allen. And so the recommendation from Sean, it seems to decide that has to be across from Lakeview Boulevard. But Lisa, I heard you saying that we might want it further north.
Well, for the reasons that you were talking about, like just looking at the configuration of the lot line there, it would seem like you'd want to have two similar sized buildings. So the driveway should go somewhere that works with that design. That was Commissioner
Right, because if
Summers.
you forced it straight with Lakeview Boulevard, you'd have to have a pull in where you're driving straight into one building and then veer north to go around to get to the other building.
someone leaving, if let's pretend the arrow is a vehicle leaving the site. If they want to go south to Madison, to University Avenue, what's their movement going to be? They're going to have to turn right,
Turn right,
or they're going to,
go up to that traffic circle that we're gonna put up in Ellen. That's a joke.
but the
That
other,
way no one from Wanakee can go through
but
there.
the potential is, if you go back to the previous one, please, Daphne. The potential that, what Sean's concern is that the potential is that someone will pull out and try and make a left turn and go at an angle to that median cut to go south. Like if there's not much traffic, they'll be tempted to say, hey, I can make it now.
Right.
You know, there's not that much traffic.
Can we require a driveway to have a little,
A pork chop.
is that what it's
is what
called?
it's called,
A little
yeah.
curve, a little
Yeah,
pork
I
chop?
thought of that as you were talking too. I mean, ideally the access would be where the arrow is. I understand the concern that Sean is raising, and then if someone's leaving that site and turning right, they're going to flip a U at, is that the term
Mendota.
that
Flip a U.
flip? Yeah, not everyone apparently. That's not.
That's not a thing.
Yeah.
I want to, who's
That's
heard
not
of flipping a
something you
U?
flip.
I've never heard it called flip a U-turn.
There, people are, I'm justified.
But you're Canadian. That's not.
Well,
I'm gonna put that in the nets. flip.
what is there we're not saying that the access point can't be there. We're just saying right now, we'd like the access point to be across Lakeview Boulevard, but it could be modified, that access restriction could be modified
Yeah.
later with a traffic impact study when we know what the plan is. And that to me seems like a solution that meets city's needs and the developer's needs. The other alternative would be not to do a 3-lot CSM and just leave lots 1 and 2 one lot for now, since we don't have, there's no firm development proposal. I'm not sure why we're subdividing the lot.
Probably
Without,
so that we can get a development proposal, maybe 2 separate ones.
but they could come back once they've got a firm plan, they could come back with a new CSM.
Yeah.
To subdivide it further.
I mean, my other concern is procedural. If we're attaching a conditionality to a CSM, it's usually something that staff has to sign off on, right? Before the CSM is recorded to create the lots. But if we're saying it has to depend upon a traffic impact analysis,
And that's why we're not.
which won't occur until we know the development proposal,
Right.
how do you attach that as a condition of a CSM and then claw it back? Because it'll already be recorded, so it's an actual viable lot.
Yeah, I would assume that there's a way for us to modify that restriction on that CSM through an additional agreement. That
We have to record it as a restriction on the CSM, and then we'd have to file an amended CSM.
Yeah.
Should go through the same process.
We've done that for other projects, the Greenway project, mixed use project. We lifted some access easements in March. So I mean, that happens. But that's why we didn't put the TIA in this, because for the reasons that Commissioner Paulson said, but we can't sign off the CSM if the condition hasn't been fulfilled.
Hoping this is a related question. Driveway off of Mendota Avenue, would it serve lots 1 and 2? Or would the only driveway that would serve lots 1 and 2 be off of Allen Boulevard? The reason why I asked that question is because if you don't line up the driveway with Lakeview Boulevard, and that Allen Boulevard is the only access to lots 1 and 2, traffic coming from the north would have no choice but to do a U-turn at Lakeview Boulevard to then pull into the driveway to get into their, if they're not lined up.
And that's
Or
why,
they would come down Mendota and then
Yeah.
swing around the back.
yeah, and that's why we, in the
Well, if
first,
they could, that's what I'm asking. Would the Mendota driveway would people who live in lots 1 and 2 have access to their buildings via Mendota Avenue?
the first contingency of approval is indication of all easements necessary to facilitate circulation or access, stormwater management, and public utilities between and across all lots. That's why we put that in there.
I just pulled up this resource here to show the concern that our Public Works Department has, which is access to the Trotta right now, and an accident that occurred in summer of 2023 where it was the same kind of situation. Somebody was trying to get to this driveway and
Actually.
yeah, there was an incident where they were turning a U-turn and it caused an accident.
It
So this
actually
is,
goes south, Abby. I'm sorry to correct you.
No, no, no.
It's actually this, my understanding is it was
That's
related to
the-
this driveway.
this one?
That was because the one on at the northern end is only the liquor store. I think well, I didn't look at the
I
crash
think
map.
she's showing an actual.
If she's showing the dot. on
This is the
actual-
accident.
Oh. Oh, so they were
And
going,
this is also a public resource that you can always access if you want to see crash data. In Middleton, you can screen it for severity, flags, et cetera. So,
well, it's very
So this
possible
means
that
that-
crash wasn't related to the Trotta then, but the point is, the concern is valid because we know that people will do, will take shortcuts if they have the opportunity to.
Since we have the applicant here,
Yeah.
I want to ask your opinion of what we just discussed. Any thoughts?
Yeah, so when we've looked at this site, we've always considered it as an internally circulating site.
I think the microphone's not on.
And I think.
Can you
this-
introduce yourself to the rest?
Yeah, I'm Ryan Hennig, Gallatin Real Estate. So when we've looked at this site, we've always thought of it as an internally circulating site with cross access across all 4 lots. That's why we've drawn the CSM in the way it is. I think Mark's point of the first condition requiring that, we're fine with that. And we would prefer the alignment to not be with Lakeview for that reason. So we can look at future phases and say, okay, we're gonna have a right in, right out along Allen, and then up on Mendota, have that internal circulation.
So would you say that the engineer's recommendation that it has to be in line with Lakeview Boulevard would render your development unfeasible?
It would contrast with how we've looked at this site. And I think from our perspective, the better local circulation is the through traffic onto Mendota versus Lakeview. It doesn't really terminate anywhere. You're just back in a residential neighborhood. So we thought it was not the best idea to direct traffic to that connection.
Can we put the map back up? So what is staff's recommendation on the language then on the site access issue?
Yeah,
I mean, we have
number
other
11.
issues we have to deal
Right,
with.
it's number
That's-
11, page, or slide 11. Also in my staff report. So the contingency currently reads the first bullet there.
No driveway access along Allen Boulevard except at the median opening across from Lakeview Boulevard.
I think from the standpoint of traffic safety, we have to really think hard about making any changes to that. If it doesn't line up with Lakeview Boulevard, it does open it up to people trying to beat the traffic flow, I guess. I mean, it's pretty, especially it's your location that you want is pretty close to Lakeview, although it doesn't line up exactly, but it's close, and that's going to really entice people to want to shortcut it, I think.
Yeah, as a driver, I know we're all drivers, but as a driver, I feel like if I'm coming from the north, I'm going to turn left onto Mendota because I have a light. Maybe I even have a left turn arrow. And if I'm coming from the south, I'm going to turn right off of Allen Boulevard. Then when I leave, I'll do it the opposite. You know, if I have to head back south, I'm still going to do the turn at the light because I turn at the light.
At Mendota.
Off of Mendota.
Is that signalized?
No, but
Not
it
yet.
likely will be.
Oh, wait, which one will be signalized? At Mendota,
Well, that's the thought. I don't know that,
not at
That's the
Lakeview
thought.
Boulevard.
No, not Lakeview Boulevard. Well, Rainey.
I feel like Kurt, I think just, and to me, it, safety wise, it seems like Lakeview is the right answer, but I'm not a traffic engineer. And I don't know what's going to happen with this other intersection that I'm not sure what the difficulty of the staff's recommendation is right now, if we are able to modify that in the future. We're talking about it now. We're saying that it's a possibility if the traffic impact analysis shows that it's appropriate.
Then with that wording, I would find that this contingency okay. I feel like if we say no driveway access along Allen except for at the median opening, any change, and we can say it, it's on the record that we fully intended to revisit that if needed or if appropriate. This is what we're going to be held to.
Yeah.
Yeah.
So we need to maybe modify that contingency.
Yes.
Okay,
Because once it's recorded on the CSM, it's a legal requirement. And so even anything just written in our notes has no legal effect until. Okay.
have we beat that to death enough?
So
Let's move on to the fun stuff of stormwater.
Daphne, I have the staff report has the, it's there. Okay, sorry. Thank you. So the red text are the changes that I just went through.
So we have consensus on number 3 to leave that as written.
With some wording to indicate that we may change this.
Well, yeah, what's the significance of 175 feet? Do you know?
That's our access.
That's our next management thing.
Oh, it is?
That is what I was given by our engineering staff as I went through the access management plan in detail today. I did not see, I saw 150 feet. I didn't see 175.
Okay.
But, so I don't know where that 175 came from. But I think based on the concept that the developer has provided previously, the 175 is not an issue, but in theory, it came from the traffic management plan.
Okay.
That's the answer.
Can we just cite the traffic management plan then and say driveway access along Mendota Avenue and Allen Boulevard to be consistent with the city's access management plan? Pending.
I don't know if that's our subdivision ordinance. Well, actually, our zoning ordinance refers to that plan. So that, yeah, that's fine. I think that's
We can
acceptable.
attach any condition we think is reasonable
Right.
for public
Right.
safety. I mean,
Okay.
just for your knowledge, if the TIA and the city engineer say, no, we can't do it, we're gonna have a very difficult time overriding them as a plan commission. And the TIA would not happen until lots 1 and 2 are proposed to be developed,
At
correct?
this point, we don't feel the TIA is necessary for development of lots 3 and 4. I mean, I'll speak for myself, but that's been what I've gathered from my colleagues.
That's fairly low density, right?
It's MRL, yes.
Any other comments?
Well, I'll just add, I'm
Yeah.
searching our access management plan now and the number 175 doesn't show up.
Right. That's what I
So
was saying.
I mean,
Well, so I think what I saw was a 150. Unfortunately, when I was going through this in detail today, it was just after our staff had left downstairs. So sorry, I didn't catch that sooner.
Yeah, and I would just add, I mean, I agree. I think it should reference something more concrete rather than an arbitrary number.
Yep.
We, of course, we're interested in public safety. I think we're concerned with the permanence, the attachment to the CSM itself of the restriction and a trouble adjusting that in the future, given whatever concepts proposed. So I think that's where we're looking for a little bit of lenience in this contingency.
Yeah, and I'm trying to remember when we ever attached a condition about location of a driveway. Because usually that is governed by setbacks and the traffic management plan, right? Because you can't build anything on there until we get a site plan approved, and that will trigger a traffic impact.
Right. I would think there are going to be future opportunities to discuss this issue.
Does the county have anything on this? Since it's a county road, do they have any requirements?
Yeah, I know, we reached out to the county to ask if they had any input, and I don't think that they've followed up with us yet. I did just want to mention that I think that the reason that we haven't attached a condition like this before is because usually we're looking at the site plan at the same time we're reviewing the CSM. I'm not sure that the city can require a TIA, because they're required at a rezoning or conditional use permit.
There's a provision in our zoning code that I found.
That you can, okay. I just wanted to be sure that we could require it.
It's section, yeah. I cited it in the presentation.
One alternative for the plan commission to consider for number 3 is to keep the language as it stands, but add an additional sentence that says, with site plan review for a future development proposal on lots 1 and 2 and a traffic impact analysis that shows viable alternatives, the city may consider an alternative access point from Allen Boulevard. Something like that, that would indicate in the recommendation that we'd be open to changing the restriction in the future.
And that would be on the CSM, that would be recorded on the CSM along with the access restriction.
I don't know if that could be recorded on the CSM or not.
Well, yeah, I think the intent was to have this access restriction shown in this CSM.
Right.
Whether adding that additional sentence, I don't see why that couldn't be added. I don't know how our city attorney would. I mean, basically it's saying we would be willing to consider it is what you just said.
Willing to consider
Yeah.
changing it in the future.
And the other approach, and I'm not speaking, I'm not advocating against what Abby said, but another way would be to say any driveway connection with Allen Boulevard will be regulated by the city's zoning and subdivision ordinances and the city's access management plan. I mean, that's a softer way to do it, but I think the way Abby described it, and for the reasons we stated earlier, yes, these things can be lifted with further action by the city. And we need that leverage now to protect the city's interests, public safety.
Right.
Well, we also protect that when at site plan review, we could just say, no, that driveway can't go there.
You can.
But we do need to make sure that we get it. How do we get ourselves the traffic?
Yeah.
And
We need a traffic impact study.
We need
because
the
none of
traffic
us are
impact study.
engineers, so
Exactly.
we need to see what they say.
Yeah. We need to make sure that happens.
So are we gonna have to wait for those things to happen before we do a CSM, or do you want to make a contingency in the CSM?
That would be my preference, is to move this along, get the CSM accomplished, and then work towards solving the traffic access.
What about phrasing it as any driveway along Allen Boulevard shall conform to City of Middleton, all applicable regulations and the access management plan. And any development on the parcel shall require a traffic impact analysis.
We had and county,
Yes, and
since
county.
since it's a county road.
So I think I said any driveway access along Allen Boulevard shall conform to all City of Middleton and Dane County ordinances
To all applicable ordinances.
and the city access management plan. And any development on lots 1 and 2 shall require a traffic impact study. Analysis?
Same thing.
Analysis, yeah.
Analysis study.
Tomato, tomato.
Study analysis.
And a traffic impact analysis is required as part of site plan review of lots 1 and 2.
Sounds good. So I guess I would make that as a motion to amend a motion that we haven't yet motioned.
There's no amendment needed since you haven't made the motion.
Okay. Well, it's recorded now, though.
I wanted to ask a question.
Yeah.
Is it possible to see what the site plan is going to look like or the concept plan for the site?
We did see a concept plan that's
Could we,
going to have to change a little bit at least with this subdivision. That was July.
I guess I'm not entirely comfortable voting on this CSM until I have a better idea of why we're breaking the 4 lots up the way that they're shown right now. I would prefer to see some kind of layout.
Can we see the concept plan from July?
I think the issue is showing it as they're making changes to the proposal for lots 1 and 2, which is why they couldn't do the traffic study at this point in time because they didn't know what their plan, what their
Right.
building plan was gonna look like for lots 1 and 2.
Given that we've shifted our focus to the eastern portion of this parcel, the next 2 lots, it's undetermined what those will be and when they'll happen. So we didn't feel comfortable providing any kind of density statistics or anything like that because we don't know what that's going to be.
To Commissioner Harp's point, could this be a 3-lot CSM? That you combine lots 1 and 2 for the time being? Which would,
I don't think we're interested in that.
okay.
I mean, if you divided that into a single lot,
It could be, I guess my point was, once you've firmed up your plan for it, then you could draw the line and be comfortable, we'd be comfortable as well as where that line would be.
and I think we're comfortable with how the CSM is currently drawn.
Because it's your intent to convey those parcels separately.
Correct.
Will the 4 lots be owned and operated as one apartment community?
That's the intention, but of course the future is unknown.
And when I saw this concept plan, I'm sorry, I wasn't at the July meeting, but I read the notes. The staff report said at that time you were not proposing a land division.
Correct.
Can we ask what's changed?
I think shifting to the lower density project first is what's changed.
It's a phasing issue.
Correct.
Anybody know does everybody know the history of what Burklows have done in that area, the apartment buildings on Lakeview, was it Lakeview Boulevard?
No.
You do they're all separate entities, right? Each building? It's just one entity? So if you sell it, you'd have to break it up into lots. In other words, if you wanted a separate parcel, yeah. So they are separate parcels now, okay.
And, just for everyone's benefit, zoning and deed restrictions attached to parcels, so we can't put a restriction on future ownership.
Right.
Right, so the only way to maintain common ownership would be to deny a CSM.
That'd be my understanding that we could Yes, we can't require separate or one common ownership, but we could have asked for I think we could ask for a management plan, overall management plan that would cover the 4 lots. If they have 4 separate lots, they're gonna have to, often they'll have multiple lenders and obviously they have to have separate owners. But in past, I've seen requirements for common management. So that it's operated, or managed as one community. Wouldn't have to be owned as one community, it can be managed as one community.
Well, presumably that would be all the easements that are recorded. Kurt, do we want to take the other issues, or Chris, did that answer your question?
It answers my question, but I'm still not comfortable voting for this CSM.
Okay.
We have
Any-
to,
To your point, are there any other issues with like 5 and 6?
well,
Basically,
and we have a stormwater issue that we need to concern ourselves with, and a sanitary sewer. Sanitary sewer is less of a problem for me. Because, I mean, the developer knows you gotta provide sewer. And we ain't providing it. So whatever way you can get it, right? It's to put a fine spin on it. I wanted to ask about the soils if we can.
sure.
So the environmental assessment that shows the DNR kind of screenshot showed the Houghton muck. And you said you've done a number of soil borings.
26.
26 soil borings. And I know this can get really boring for everyone. I don't want to muck it up. I'm sorry.
Don't get
Too
Mark
easy.
going now.
Yeah, too easy. Did any of those show the presence of substantial organic material that would be associated with muck?
I mean, there's a wide variety of materials on the site, so it depends on what location you're in.
Because my concern is under Middleton's ordinance 19.032, which I don't know if we want to pop up. We're supposed to determine land suitability consistent with the CSM. And all we have is there were soil borings done, but we don't really know what those are. And we're not really, I mean, some of us took a soils class, but that was 30 years ago, so we're not really soil engineers. The issue seems to be, should the plan, in sub B there, should the plan commission determine the land is unsuitable for development, we would need to state our reasons and find findings, and you could contest that. But can you help us out to think about whether the land is suitable for the proposed uses? We don't have a specific use, but we know that it's going to be zoned a certain way. So the CSM creates a parcel that creates a certain zoned way. So we determine land suitability relative to that. Do you want to address what that? You're confident that your engineer and soil expert has said that you could build what you're proposing to build on the site.
Yes.
And our city engineer, our stormwater engineer, I asked him this question as well, and he said that the soils data, the borings that you mentioned were submitted as a component of the stormwater management plan, and that's now under review.
Okay, so they have that. Okay.
And furthermore, the design of each of the building foundations would need to comply with building code, standards.
Well, and given that this is in our subdivision ordinance, land suitability can mean lots of different things. Whether that's the best use for the land is different than whether with expensive engineering you can make it work, because presumably you're going to need to do some pilings and foundation work,
Possibly.
right? So we're not concerned about how much that costs you. We're concerned about the impact on neighbors and the like. So. I mean, it sounds like that requirement has been met, right? That the land is suitable. I don't know if we need that finding that it is suitable or just approving the CSM is finding that it is suitable. But I know that's what the neighbors were concerned about. So certainly when you get to the stormwater plan, I mean, just for everyone's understanding, if the stormwater plan comes back and the stormwater engineer says, no, it's not adequate, then you can't build until you get approval. Right.
And I thought Mark did a good job of answering that in his note to the updated note to the Plan Commission. You know, regarding the suitability of the soils. I think the you know, the muck designation was general, wasn't specific.
Oh, yeah.
We do have future there's future requirements that are going to still be enforced that are going to ensure that the site's suitable for the building or the.
Yeah. Yeah, and I just wanted to talk it through since that was a email that came to us at 4:13. So we have to make sure that we're kind of reading that into the record. So
How far down is the sand there?
I'm not sure. I'd have to look at boring logs and it may vary.
Just curious, because if you do pilings, you gotta get down to the sand, as I recall.
Yeah,
Okay,
we got engineers looking at it.
yeah, all right.
thank you. Yeah, our ordinance is a little, I didn't really know what we meant by land suitability.
Mhm.
Because usually that's a technical analysis that requires,
This will be cleaned up in our new subdivision ordinance
Thanks.
under development.
So items,
What about this? What about item 4, the stormwater management agreement? Do we want to just talk about that now? I mean, for me, it seems like the stormwater management plan's been, if I understand, has been submitted.
It has.
That has to go through our review and approval process. That's going to happen in any event. Is that, I mean, so I'm comfortable with that requirement or that condition.
Okay.
And I don't think it's onerous at all.
and we require it of everyone.
And we require it of everyone. Yeah.
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 And I do know that neighbors are concerned about the stormwater, but you can't wait to approve the CSM until you get the full stormwater plan. That's why we put it as a condition that the city engineer has to approve the city stormwater management plan.
And why?
And if he doesn't approve it, then you can't build,
Right.
even if the lot has been divided.
Yeah.
Sorry, Lisa.
Why add the part about the agreements recorded for all 4 lots?
That was
When we don't know what 2 of the lots have proposed for them?
Matt Fleming's feedback on this today was that he wanted to make sure that all 4 lots, because they could become separately owned, we're aware that there's a stormwater management agreement or stormwater management plan and agreement that pertains to all lots.
And
So-
I'm assuming that the 4 lots are going to have a lot of cross access for
Right.
stormwater. Water is going to run from one lot to the next lot. Some of the lots will have management basins and others won't, or, you know, they're going to be commonly managed. So they'll have to have some sort of group management plan.
okay. Anything with item 5 or 6? Pretty straightforward. So we're gonna stick with 6 conditions here. Or
May I ask-
contingencies, I guess.
Can I ask
Or-
about item 5?
What about it?
It's always bugged me the way this is worded. Shouldn't it read something to the effect that they will pay the appropriate fees as determined by the,
I think that's implied.
nothing's implied.
Well, our ordinance
Everything's
requires that,
subjective to who's
that
reading
then
it.
we,
Yeah, I get that.
as a condition of site plan approval, it's written right in there. But we don't know if it's gonna be a 100-unit building or a 50-unit building, so that would,
Right. But yeah, okay.
He just wants the word pay in there.
No, I just want to make sure, I mean, because everything else is, this needs to be done, this needs to be done, and then this one's kind of like, the plan commission is going to do something.
I see
It
what you're
doesn't
saying.
have anything for the developer.
Yeah. I
It's
see
all
what
on
you're saying.
us.
Yeah.
Yeah.
Park
Is it,
fees
is
are-
it, is it even necessary for us to have that in there is what you're saying, I think.
Yep.
Because we're gonna do the site plan review and then the park fees will get determined.
Right.
That's just what's gonna happen.
Yeah, I mean, think of all the contingencies that could be included if we included everything that's going to happen.
Yeah,
There will
right.
be a site plan.
Yeah.
Yeah.
True.
Yeah.
So, if you would. All right.
So I would.
So
take
you'd
that.
strike it?
5.
Okay.
And then where did we end up again? Could you just help me on number 3? Where did we end up? What was our final?
I think Abby
So,
had a,
yeah, we suggested some language as the highlighted in yellow on your screen,
oh, there it is.
based off what Commissioner Paulson
Any
said.
driveway access along Allen Boulevard, I'm just reading it into the record for people who can't see the small print. Any driveway access along Allen Boulevard shall conform to all applicable city and county ordinances, as well as the city's access management plan, and a traffic impact analysis is required as part of site plan review of lots 1 and 2.
I think it should also say Mendota Avenue. Because
Any
Any
Mendota-
driveway access along Allen Boulevard and Mendota Avenue.
Yeah, because Mendota
Shall
is the one
conform.
that was linked to the 175 feet, which we don't understand why that's a.
So just adding and Mendota Avenue. Okay.
Yeah.
Mhm.
Okay, and item 2. And is that read as that as it should be? It was a long discussion.
I guess I'm wondering what replenished or increased. Why is that in there?
The funds in escrow for the study.
Right, no, I get that. So shall be replenished if
If we
25,000 is.
Right, that's what
spent?
Matt Fleming recommended,
Okay,
language that he gave me.
Lawyers
And,
right.
and I want to emphasize the city engineer didn't think it would get anywhere near, I mean, he thought it'd be in the low 5 figures is what he estimated, so.
yeah, I have no problem with that. Can we indicate that 5 is struck out or is that not, is this a PDF? I guess this is a PDF.
We'll strike it. Any comments from applicant at this point?
Nope, not at this time.
Okay,
Maybe just draw an X on number 5.
We're working on it. There, we
Oh,
can
yeah,
see
we
it
can
now.
see
There
it.
it goes.
Yeah.
Very faint.
And do we just, you want to X out, strike out 3 as it was originally? Yeah.
And again, we're approving it. We're not recommending approval to the council.
Right.
We have the approval authorities.
okay, is there a motion?
I would make this motion. You gonna make me read it?
No.
Okay.
You got it memorized yet?
No.
Is there a second?
This is an IRO, I'll second.
Been moved and seconded. Any discussion, further discussion?
I feel like there's too many unknowns with this property for me to be comfortable voting for it, so I'm
Okay.
gonna vote no.
Very good. Anybody else? Hearing none, then I'll call the question. All in favor?
Aye.
Aye.
Aye. Opposed?
Opposed, nay.
Okay. Thank you, one and all. Power's on.
That just randomly went dark on us.
Not a good day for tech.
No.
There's gremlins in our technology, I think.
The power button just.
No, yeah, we tried the power button and it was saying that
No,
it
it's off
didn't have
now.
an input.
Oh, no, it's on. I'm sorry. There it is.
It's not
Would you like me to double
displaying
fund
what's
boring and mud?
there. You can share my screen.
Okay.
You could sit down here if you want. I can move over.
I think that was the tough one. All right, we'll wait for Mark to get back in here. Oh, there he is. Okay. Item 3 on our agenda is referral to committees, preliminary plat and site plan for the Ziegler Farm neighborhood by Viridian Homes, lands east and west of High Road. And I don't know, let's go to the back.
There are 5 committees that we're recommending that this get referred to. We're not proposing any discussion or presentation tonight, just a referral.
Oh, there'll be a hearing at the next meeting on the zoning request.
Okay,
The date of November 20th. Let's see, where is that?
under recommendations.
So that's for them to get the recommendations back to staff so that it'll be in the packet for the plan commission meeting. I support this. I just want to ask, what are we asking of these committees and commissions?
I was gonna ask the exact same
Yeah,
question.
because if you recall, we went through a lot after not accepting or not following the guidance of one of the commissions in response to a question about feasibility of, you know, what would be a good zoning district for the property we just discussed. So that made me realize we always need to specify, here's what we're asking you to provide input on. And for that reason, I think we need to have some discussion about what specific question are we asking each of these. And I would also note that I'm fairly certain the Sustainability Committee wanted to see it, and that's kind of what triggered in my mind the wondering about, well, what's the question we're asking for input on or feedback on?
And the recommendation said preferably no later than November 20th. And our past experience is, no, we give a deadline.
I
These
agree.
committees, you snooze, you lose. If you don't respond, you can't.
Yep. If you're.
Because there was
meeting
one thing we referred and then they didn't meet for a month and they didn't have quorum and then you're waiting and you know.
I was being very nice. I'm sorry.
I don't know
It's
that
the Canadian.
specifying a question to these committees makes a whole lot of sense. I mean, the committees are discussing within their own committee issues that they think may come up with.
Mhm.
I don't know what,
I know the WRMC asked at their meeting a couple times, what are we being asked to
Mhm.
weigh in on? And now, you know, it was not a, it wasn't a preliminary plat referral. In fact, they were looking for something like that. So maybe that was just a unique situation, but I guess maybe if we specify, I don't know.
But we're referring specifically the preliminary plat and the site plan, and each of these committees has areas of expertise.
Mhm.
So I'm not sure what else you want me to specify, what you are looking to specify.
It's a little hard to do at this point.
I agree. I just,
Are we just asking for recommendations from those committees related to their specific review of the preliminary plat? That we then would weigh?
They're providing feedback, whatever feedback is. At this point,
Yeah.
I mean, they're,
I
They can
get
choose to
it.
provide no feedback.
Right, I get it, but I think Commissioner Adams gets
Yeah,
what I'm,
yeah, because in 2 weeks, and when this comes on our agenda,
Mhm.
you know, I would like to be able to give the committee direction about this is what this is what we need to discuss at this
Yeah.
meeting. And, you know, I'm thinking like, okay, park locations, sizes, that type of stuff, that is
Sure.
things I could come up, you know, to discuss at our meeting, but I'm not sure if there's anything else that this body is looking for from PRFC that we can discuss.
I think with regard to CLC and PRFC, it's probably of this list of 5, it might be the most straightforward because the developer is proposing some lands to be dedicated park and to be zoned conservancy. We don't know whether or not it would be dedicated to the city and under city ownership. Another issue to consider is that we have a Graber Pond study that has recommendations about setbacks from the wetland. So CLC would want to take a look at some of the previous reports and studies that they've approved and whether they feel that the development complies with those. Parks is going to, based on the unit count, if 173 units ends up being approved and finalized, then the city would be able to assess either parkland dedication just under 6 acres or instead apply a fee in lieu of park dedication. And I've been working with Kylie and Daphne on doing some mapping of the other parkland in the neighborhood and what the walking distance is for each of the parks. So there will be, I think parks will have a pretty clear packet of information to consider once it goes there. For Ped Bike Transit Committee, Mark had some different thoughts about a path that's a regional bike path that's being proposed through the neighborhood in order to better align with their adopted plan. So I think that that's probably the primary focus for Ped Bike Transit Committee. Public Works would be looking at the street network and connections to High Road. And then Water Resources is probably the most vague in my mind because typically Water Resources Management Commission would review and make recommendations on citywide policies, or they would actually be reviewing a stormwater management plan. And we don't have either of those with this project yet. And so I think that there might be a little bit of gray area in what they should review. So if there was something specific that the Plan Commission wanted them to take a look at, it probably would be helpful to firm that up a little bit.
But at the same time, the stormwater engineer, as he reviews the plans, might find some policy questions he wants the committee to address. So I mean, I guess that's why it was meant to be
Yeah.
open to,
open-ended.
you know, we don't know what all the committees,
I don't think we have to tell them, but
right.
I would want Water Resources to also consider Graber Pond
Yep.
So,
and the effect on the conservancy, the creek. Doesn't some of this drains to the creek, right?
Yeah.
so we covered all the committees?
Alder Haniro had mentioned that sustainability wanted.
Oh,
well, no. I'm not going to propose that they review it. I just am aware that there's some interest on the committee, but I'm not a member.
We can,
so-
They can
we
certainly
can add them.
decide to put an agenda item on just on their own to refer to make comments to us about something.
Without us asking.
Yeah,
Yep, I like that.
but they would have to notice it as on their agenda item.
Sure.
Mhm.
And that's one more meeting for Brian to attend and
They meet on the third Monday of each month. So they would meet on the 21st and the 18th of November.
I don't know if this is an appropriate time to ask Public Works to consider this, but at the neighborhood meeting, one of the biggest concerns expressed by the neighbors was not with the development itself or the proposal. It was with the condition of High Road. And once this parcel is annexed to Middleton, we will have more control over all of the parts of High Road that need to be redone. So I guess that might be a specific question for Public Works to consider. I know separately from that, I will be pursuing that as the alder from this district. Because I understand that we have money in escrow, and when Viridian pays the fee for this, for their part of it, we'll have enough money to do the road. So I guess I would like to ask the Public Works Committee to consider the earliest date that this road could be redone.
Mhm.
Right now it's in there for 28. But that seems too far. And then also on page 51 of the packet, there's a statement that there are no mapped environmental corridors. And I don't know if that is very technical, like there are no mapped environmental corridors, but the two parcels that are in the town of Middleton, just north of the big outlot on Whittlesey Road, those show up in the Carpsey environmental corridors. Yeah, so I just thought I would note that.
And those are delineated wetlands already, right?
Yes.
Yeah.
Okay, so we're just making a recommendation for a referral to these committees. Is there a motion?
I'll make that motion to refer them to the committees as for the staff recommendations.
Is there a second?
Adam's the second.
Moved and seconded. Any further discussion? Hearing none, I'll call the question. All in favor?
Aye.
Opposed? Motion carries. Item 4 is the official map concept review of the proposed revisions. I don't know, what are we revising?
The official map.
Oh, the official map.
There's a list of,
You didn't read all the statutes?
No.
on The official map?
I
and
didn't.
statutes?
so we identified through the work session that Abby, Daphne and I had, we identified this list of changes that we're proposing. We just wanted your go ahead before we went ahead and updated the map. So the Greenway east of High Road, I don't think I need to read all these.
No.
May I ask about the timing of this? So does this need to happen before, like, I know the Ziegler proposal does not conform to the official map. Are we doing this now because we have to, or can we wait until they're? Yeah, I guess I'm just trying to figure out why we're doing this now as opposed to any other time.
My first response to that is it's good to do this every year. But we saw an opportunity with a few issues that had come up to just do a comprehensive check. We just went through the whole city and looked at, we didn't just focus on the Ziegler property. We looked at the whole city.
I think it's good to keep up with it
Yeah.
because you're really trying to reserve future, yeah.
Sure, that's fine. I was just asking because I know, has it been updated yet to show that Bellefontaine Boulevard isn't going to be two driving lanes in each direction?
That's something that's more finesse that wouldn't show up on a map as well because the map is
Pretty tiny.
Okay.
Yeah.
It was updated though to map the new corridor. for
Yeah,
both.
I was just so the alignment of Bishop's Bay Parkway was changed a few years ago when Red Tail Ridge came in. Actually, it wasn't Red Tail Ridge, it was the purchase of the county's purchase of the acre farm.
Yep.
That required us to realign Bishop's Bay Parkway.
Bellefontaine Boulevard.
But the official map for Bellefontaine would still reserve that right of way. Right? We're not vacating that right of way.
No.
Yet
The official map of Red Tail,
of Bellefontaine.
from
Right.
Missy Valley.
So the plating locks that in place.
Yeah.
What's it
I
called?
mean, so we, just anytime something's platted, that essentially updates our official map. With Bishop's Bay Parkway, jumping ahead, we,
Do that.
in the town of Westport, we approved a phase that shifted the alignment. And therefore we felt that it was appropriate to, or it's necessary to shift the alignment so we still maintain connectivity there. So that's why that one, number 3 is there. The rest of these were,
Oh. Mark, I don't even know that you need to go into all those.
okay.
Can you bring up the map? I think it's on page 67 of the packet. Well, actually, maybe not.
For what reason?
60, because I wanted to show a polygon that is incorrectly colored. So the polygon north of the Whittlesey Road path. So that is all going to be green, correct? That little triangle part. Yep, right there. That's already on our zoning map as conservancy.
It is.
So it should be a solid green is what you're getting at. Yeah, I agree with, I noticed that before too.
Okay, is there a motion to?
I would make a motion to direct staff to revise the official map based on the proposed changes and to refer the draft to the Ped Bike Transit Committee, Parks, Recreation and Forestry Commission, and PWC, Public Works Commission. A lot of acronyms in our.
Yeah. Is there a second?
Harple second.
Seconded and, or moved and seconded. Is there any further discussion? Hearing none, I'll call the question. All in favor?
Aye.
Opposed? Motion carries. Okay, that gets us to item 5, the presentation and discussion of potential impacts to the city from the town of Westport's petition to incorporate.
And I'm actually going to share this directly from my computer screen here because I updated the slides that were in the packet. Commissioner Paulson had asked that we include this on the Plan Commission agenda. Our council also had a discussion of this and were briefed on this in closed session at their meeting last week. But I just wanted to provide a little bit of history about the city's intergovernmental cooperation with the town of Westport. So on September 23rd, the town of Westport Board of Supervisors voted unanimously to support a petition to the state to incorporate the town as a village. They had 3 primary stated purposes. 1 is to control their growth and land use. 2 is establishing fixed borders. And 3 is to prevent ongoing annexations from eroding the town's jurisdictional boundaries. There is a website that they've set up where they've been updating information. There is a 10-day waiting period from the date that they decide to file the petition. They had that 10-day waiting period, and then they held 2 informational sessions and gathered signatures from more than 100 residents, which was more than the needed signatures. And on Friday of last week, they filed the petition with the Dane County Circuit Court. This is a graph or a map, mapping exercise that shows the municipal incorporation process. This is from the Department of Administration website. So the first step is to publish a notice of the intent to circulate a petition, the 10-day waiting period I mentioned, circulating the petition, and then within 6 months, filing the petition with the circuit court. So that is yellow. That's the square where the process is now. Once the circuit court publishes a notice of filing the petition and a date for the hearing, the city will be notified of that. To my knowledge, that has not yet happened. And then the city, as well as other area municipalities, will have an opportunity to become parties of interest to the petition. So that's what's shown in the blue here. So that I think is a decision that the Plan Commission and working with the Common Council could make if the city of Middleton decides that we want to become a party. The circuit court would then conduct hearings on the standards. The city and any other municipalities would have a seat at the table and be able to provide testimony for that. And then the circuit court would forward the petition to the incorporation review board. There are several other steps that are involved, but the one that I really wanted to draw your attention to is after the process has gone through the circuit court, there is a publication of notice of referendum, and the town would need to hold a referendum and allow their residents an opportunity to vote on the incorporation. So a little bit of information, differences between towns and villages in Wisconsin, and villages are pretty similar in statute to cities, but I'm focusing only on villages because that is what the petition is about. So towns are unincorporated areas created by the Wisconsin Constitution. They provide basic municipal government services such as elections, property tax administration, road construction, maintenance, and recycling. Villages have more power to govern themselves. Villages can expand their boundaries through annexation of adjacent unincorporated territory. They have broad authority to foster economic development through creation of tax increment finance districts or TIDs. And villages typically provide a full range of services, things such as public water and sewer systems and libraries. The League of Wisconsin Municipalities has a guide that provides more information about some of the differences between cities, villages, and also towns. Some history on intergovernmental cooperation with Westport. In 1997, the city and the town began discussions regarding an intergovernmental agreement or an IGA. And in 1998, there was an IGA that was adopted, which provided a framework for extraterritorial zoning or ETZ. In 2000, the town and the city jointly wrote and adopted a comprehensive plan for the Middleton Westport Joint Planning Area. And then immediately following that, we collaborated with the town of Westport and established extraterritorial zoning. And then in 2010, from my read of all the records, the town of Westport approached the city and asked for an expansion of the extraterritorial zoning area. So that was expanded in 2010. So since 2000, for the last 24 years, the city of Middleton has been handling zoning administration in the area that is covered by the ETZ. We established I think that's the next slide. Oh, actually, it's not. But we established a joint committee, which 3 of you serve on, along with 3 members of the Town of Westport board. So it's a 6-member commission that is guiding decisions that happen in that joint planning area. This map is showing, it's from the original IGA planning area from 1998. And you can see that kind of the northern boundary of the planning area is County Highway K, and the eastern boundary is Highway M. This is Highway Q, and this is North Lake neighborhood. There's a Century Farm north of North Lake neighborhood, and the planning area goes all the way to what we know as the MRD site, the refuse district site, where we have the dog park and the compost facility, and further north of that to Q.
Okay.
Or I'm sorry, K, thank you. Within the comprehensive plan, which, as I mentioned, was jointly written by the city and the town and approved by both bodies, there is a section in that plan that's called long-term growth boundary area. But I copied the language directly from the plan because it's interesting. It's a little finicky how it's written, but it says the line shown on the map as the ultimate City of Middleton boundary is not going to be established by this document or by any process related to this joint planning effort. So it wasn't firmly establishing that as a line, but it goes on to say, this indicates an area which is mutually agreed that the city has a reasonable present or demonstrable need for the property if annexed and is best suited to serve such property with utilities and other services due to natural features or close proximity to the city. So that long-term growth boundary area is what is shown in the purple line on this map. And we had to recreate this because the comp plan does not have any maps associated with the approved version, but it has a very good description of what that line was intended to be. So that is essentially on the north side, it's Onken Road, but it extends further west of Q beyond the boundaries of Onken Road. And then it follows a line through Community of Bishops Bay and south down to Century Avenue or County Highway M. Yeah, yep.
This was just written in a plan. It was not a cooperative boundary agreement.
It was written in the comprehensive plan that was approved by both municipalities. Yeah. One of the things that Mark and I were surprised by is if you look at the long-term growth boundary line, with all the caveats from the language of the plan, what was finally agreed upon between the town and the city for Bishops Bay actually extended further east of that long-term growth boundary line. And I can tell you that the city and the town staff, as well as the developers, met collaboratively over the course of many years to review that development project. So that was, at no time was that contested from anything that we could find in any minutes. It seemed like it was mutually agreed upon. And so the thin black line is the city current boundary line. So you can see it does extend beyond that purple line.
Abby, isn't that the area that T-Wall had wanted to adjust in that line?
Yes,
The piece they want to adjust?
it is. And the detachment proposal or the concept of the detachment does not follow this purple line either. It follows a different line based on how he would like to revise the master development plan. But it does affect some of that land, yes.
And how far does Westport go as you're going from east to west? Is it at our current boundaries?
The thing.
The map on
So everything to the left would be town of Springfield, right? To the west, sorry.
To the west, yes, that's correct. Everything west of here would be Springfield. And actually, if you look at the map on the right-hand side, this is the map that they're using for their proposed incorporation territory. So the red is the town of Westport, and this is their proposal for what they would like to incorporate as a village. And then I tried to outline this same boundary of this map down here, just so you can see that some of the areas that were in that long-term growth boundary for the city, such as this little piece here on Onken Road, this area here, which includes some farmland and also a small subdivision. And then also this area here, these were all in the area that was shown as this would likely become City of Middleton annexed property because we would be able to serve it. And that is showing up in areas that they would like to incorporate. So those might be a few areas that the city would want to discuss with the town. I mentioned that we have a joint zoning committee that you can see the makeup of the committee here. This board has been established for 24 years and has met regularly as needed.
So will this eliminate the need for that?
It would, yeah. We would no longer have zoning authority over any of the areas.
Once they establish the boundaries, I mean.
Right. This map, I'm just showing how the ETZ was expanded. So the crosshatched area is the 2010 expansion, and anything that's shown on the map in color but not crosshatched is the original ETZ area. The process for extraterritorial zoning is that all parcels that have not been rezoned since the agreement that was jointly approved, county rules still apply for those existing properties and land uses. But if a rezoning or a conditional use permit is requested within the ETZ area, the property has to be rezoned to a district that's in the city of Middleton zoning ordinance. But the city of Middleton, working with Westport staff, has added several districts to our code that reflect the type of growth that the town of Westport wants to see, which, as stated in their petition, is large lot, single-family housing primarily.
On septic or on well? Or I mean, on well and septic or on public water and sewer?
That's a good question. There are portions of Bishop's Bay where they are served by City of Middleton water, but we're only selling them bulk water at a point, and it's metered, and they are using their own distribution lines to deliver it to the customer,
It's kind of a
basically.
mess.
They have a sanitary district,
Yeah.
right?
And that include, they
Is it
do,
Westport?
they
Yeah.
do, and it serves part of the city of Middleton.
Yeah, so there's a mutual arrangement there where we are selling them water in Bishop's Bay, and we are within their sanitary sewer district in some parts of the city. So here's the steps involved with a rezoning within the ETZ. There's a preliminary discussion with city and town staff, a consultation with the joint committee. There's a hearing at the joint committee and also a hearing at the city council, and then final action by both the city and the town.
The joint committee being,
The Middleton Westport Joint
Hmm,
Zoning
which
Committee.
goes away.
Yeah, which would go away,
Okay.
right, under the proposal, correct. I guess the last thing I wanted to just mention is there are many ways that we have collaborated with the town of Westport, but I think the one that this commission is likely the most familiar with is the community Bishop's Bay, because it is a community or a large neighborhood that is within both jurisdictions. And the last time we had an item on the Plan Commission agenda related to Community Bishop's Bay was the concept review for detaching a portion of the neighborhood to the town of Westport. And I just wanted to briefly provide you with an update that that was sent over to the Common Council for their consideration, and they discussed it and deliberated it and had a presentation from the developer at their meeting. But and then they directed staff to set up a meeting jointly between the town of Westport and the city council to discuss this once there was a master development plan update. But we've had some meetings with the developers, but we have not yet received an update. So we don't have anything to share at this point in time. So that's why that meeting hasn't taken place yet. We do have a meeting set up later this week with Town of Westport staff to learn more about their petition to incorporate and what their goals are, and to discuss that with them. So that is all I had in the presentation. Happy to answer any question or take any feedback.
I have some questions. Do you have a copy of their petition? Has that been made public?
I have not seen a copy of it.
Because in the steps you show from the DOA, there's one step that's not included, which council might not even know of. The council by a 2/3 vote could tell the court that they agreed to provide public water and sewer to an area. And that would then trigger certain court review about whether that area would be incorporated or annexed. So I was just wondering if council had considered that. I know they can't talk about what they talked about in closed session, but has staff talked to Wanakee and find out what they think? Because
Our-
presumably this affects Wanakee as well.
Yeah, I haven't been part of those conversations, but our city administrator has has had conversations with Wanakee.
The top.
Any other discussion?
I mean, I have a lot of thoughts, but
You want to keep them to yourself? Or?
I might want to keep it. But I'm saying we need to really think about this because it would landlock us for any potential future growth to the north and east, and it doesn't take a rocket scientist to look at the map and say, we're kind of running out of room. We've been good neighbors by sticking within our boundaries mostly. But given the huge demand for housing and the shortage of all types of land, you know, you just look at a map and, you know, I'm not saying what we should do as a comprehensive plan, but it's not too hard to imagine that our growth area could be up towards K or Onken Road at least, but K. And Wanakee probably wants to come south to K. I can understand why Westport is worried. But, you know, I don't know if we want to make a recommendation as the plan commission, but we should just express that we're worried because we're kind of running out of room and this would landlock us on a certain direction. And it's not too hard to imagine. Some of our other neighbors might also get that same idea. And then, you know, cities, if they can't grow by net new construction, then we're really stuck in our ability to
Kind of like
fund
Monona.
basic public services. Yeah, we'd be like, maybe not as bad as Monona, I mean, in terms of being stuck.
Sure.
But
Well, I mean, a lot of what we've done in the past and currently is with our intergovernmental agreements with these communities. We've kind of mapped out our growth area, which is north.
yeah,
I don't know how much that would change with this.
well, that's the question is, do we have our comprehensive plan, what we said we need in like, so maybe we don't need that much in 20 years, but 50 years from now, we might need quite a bit going north. But once they incorporate, we're done. And my personal view is this is like an existential threat to the city of Middleton, and we should advise our city council to strongly oppose it. But
Kurt, as long as their boundary respected our growth boundary that was part of the agreements, would we be okay?
if you look, it doesn't, because
I understand that. I saw that.
whatever is the territory they have, once they incorporate, it's never going to change boundaries.
Yeah. So
if we had some agreement where, I mean,
they kept to this purple line.
it might be that this is a move on their part to try to get us to do an intergovernmental boundary agreement. And those become binding for 20, you can make them binding for up to 60 years. And so maybe that's what they're trying to negotiate with us and Wanakee, where we all agree on what the boundary agreement is,
Mhm.
right? This is what we're trying to negotiate with our town to the west as well. But yeah, I mean, we had something that looks like an agreement. At least, and now they would
For 25 years.
not show.
Yeah.
They would take some of that land away.
Yeah, I would agree with that.
I mean, the statutes for incorporation argue that one of the requirements is that you have to do it so that you can provide water and sewer for economic development purposes. But it doesn't sound like they are necessarily planning to do that. I don't know. I just want us to be aware that we could one day wake up and be locked in with no more land to develop. Maybe not in my lifetime, but
Well, Commissioner Aniro, can you take that message to council?
Can we get a motion to make an ask of council?
I don't know if we want to
Make it that formal?
make
Yeah, I
a
don't
formal
wanna make it that
recommendation
formal.
unless there's a strong view, but
Okay.
of the other commissioners.
Well, I guess is there consensus on the commission? Others share the same concern?
Yeah.
Right.
Yeah, it's a concern. It's not a directive to council that we want them to do X or Y, but we have to protect our right to grow responsibly like we have done, which is incrementally at sufficient densities to provide water and sewer and public services.
Okay.
Great.
If they're just.
I don't know what's driving this.
Well, since we're meeting with staff, I'm sorry. Kurt.
Go ahead.
Since we are meeting with their staff, on Friday, are we hearing, are Abby and I, Daphne and I hearing that as long as, if we have the boundary that we've agreed to through the intergovernmental planning we've done, if that land remains in the city's control, if you will, or is not incorporated, if that part weren't incorporated, is that consistent? I mean, that would be consistent with our 25 years of planning. The problem is, as
Historically,
Commissioner
it would
Paulson
be.
noted, once you incorporate, it's locked in.
And it can't not be incorporated
Right.
because it would either be annexed to the city immediately or it would be incorporated in the town. Otherwise,
Right.
it's an island and
So
it
if,
can't happen.
and
so
I don't
it's-
know what the annexation law is, but if those lands could be annexed, if they were to incorporate, does that change your view?
Well, that would require a landowner in those areas to petition for annexation. Because the city can't forcibly annex land that a landowner is not arguing for unless,
Right.
well, I mean, in extreme cases.
Yeah, we're not gonna.
So that would be, that would something I would strongly urge city staff to make sure. It would be much better to negotiate an intergovernmental boundary agreement
That's where I was going with that. Yeah.
and do it like we're supposed to, which is through negotiation and consensus. And
We have that now. don't we?
we don't have an
We have an
intergovernmental boundary.
intergovernmental agreement.
It's an IGA, but it's not a
There are
boundary
different
agreement.
Not a boundary, okay.
I mean, an
He's talking
intergovernmental
legal
agreement is a
stuff.
softer, is kind of a softer thing,
Yeah.
Right.
right? It's an agreement, it expires. A boundary agreement is, you draw a line on the map and it's pretty fixed.
Gotcha.
And from their purposes, what's the pros and cons of their becoming a village versus the intergovernmental boundary agreement?
So if they incorporate as a village, once it happens, every land in their jurisdiction is under their control. And because their corporate boundary would abut ours, we have no extraterritorial zoning. And so for their current residents, it's a way to, well, at least the language in public was to stop our further annexation north and to stop Waunakie's further annexation south.
And they have more economic development tools.
Yeah, and you can use TIF
Mm-hmm.
and you can use other village powers. But you also have to provide village level services, which would mean higher taxes for their residents.
Okay.
They would have to have a police force, I think. Not necessarily. No. I mean, most towns don't have their own police force. They use the sheriff's department.
There are villages that have their own, have these in county.
Yeah.
So, yeah.
Yeah.
They need to have something, but it can be contracted.
You need to have something. Yeah, you don't have to do it yourself. You could contract with Middleton. I don't know if we'd want to do that, but contract with the county.
Any other discussion? I think we beat that horse to death.
Oh, we haven't even begun. No. Everyone wants to get them.
But it's not a mayor.
Said the
form of
professor.
government.
No.
That was good.
All right. Let's move on to item 6. Zoning ordinance, chapter 10, continued discussion of potential revision.
Mark?
Yep. So at your previous meeting, you asked us to come up with with 2 versions. So what I thought I'd provide, I went back to look at our ordinance from prior to March 1st and also compared it with Fitchburg, since that's been mentioned previously and it's identical. So that's number 1, referring to the mean ground level immediately adjoining the front of the structure and then to various points depending on what type of roof it is. Then there's number 2, the Madison ordinance, which Commissioner Paulson helpfully referred me to the diagram, or referred us to the diagram last time, which is further down here. And so this is straight from the Madison ordinance. Variations according to the type of zoning district. Typically, the downtown and highly urbanized area has some different measurements, but otherwise they have their ordinance broken down by accessory buildings, principal buildings, and new buildings, alterations, et cetera, of existing buildings.
Can I just say,
Sure.
to Bill Connor's email from last time, this diagram that is shown here for Madison, where we measure from the highest point of the street, only applies in the downtown and the mixed use, urban mixed use districts. It doesn't apply in all their districts.
Correct. Yeah. Correct.
Thanks for clarifying that.
And so most of their residential districts have the, if we can scroll up, the average height. Principal building's height is the average height of the building.
And Mark, is your understanding, your interpretation of our current definition, it seems to me very similar to how Madison's definition is. It's worded a little differently, but I think the effects are very similar. There's kind of an average of all 4 sides. Ours looks at it based on the 4 corners of the building. Seems to me to be quite similar.
Don't disagree. I thought we might get an email on this subject, but we didn't. From Bill, did you get one?
No,
For this
we got the email from Mr. Wall a few days ago about this.
Yeah. He wants to go with the International Building Code.
Yeah, I saw that.
Oh,
Yeah,
that
but
one,
this
okay.
is a zoning code, not a building code, and building code is primarily for
Right. No, I recall that.
fire protection and all those things. This is about how it interacts with the neighboring properties, so it's not the same thing.
Can we go back to the image? So you're saying, Commissioner Paulson, that what we're looking at right now only applies in Madison to their downtown and mixed use districts?
The most urbanized districts.
Okay.
Where
But-
where you're maximizing height. Because
Right.
you're measuring it from the highest point.
But our code, the way it's written right now, applies everywhere. Our definition,
It's
Our
not,
definition would apply to what for them is most of their less intensive districts.
which is much of their city. I mean, it's
Yeah.
most of.
so are we unnecessarily limiting density in our downtown and urban districts by,
No, because most of those are not sloped. And so the height limit is the height limit that's already there. Measuring height only matters when there's a significant grade across the parcel. Otherwise, the height is the same on all 4 sides. On a flat parcel.
right?
Yeah.
But it still brings up the issue of, is a 5-story building with a basement garage showing from behind a 5-story or a 6-story building?
But we changed everything to height, not stories, right?
Well, that's,
Same.
We're
we're
proposing,
heading in that direction, yes.
and it's measured from the ground level.
But what's,
The
but is it the
average-
front or
average
is it
ground-
the average?
ground level? right?
Yeah.
And I guess what I'm wondering is if Madison in its downtown and mixed use districts specifies front facing or front of the building or street facing,
Mhm.
why would we do it differently? Like, what's the
No, that's a good
benefit?
question.
What's the
Because we,
benefit for us to do it differently?
because we do have that step back provision if it abuts other districts.
I would argue that our then outside of Greenway Station, we don't have densities that approach where Madison's higher densities are. I mean, And nor, I don't think that was necessarily our intention. So, I had been kind of advocating to keep the definition similar to what is currently proposed, because in the few cases where we do have sloped sites that, you know, where people are thinking, okay, we agreed on 5 stories or perhaps 6, but that's what they would see, and not to have an additional story, you know, present if they're on the downhill side of a slope site. That was my thinking. We just came through a pretty contentious or pretty big zoning overhaul. We increased heights and densities significantly. And for the time being, I felt like that was adequate.
If you look at Madison's ordinance, they say no portion can exceed that height by 15%, which the way ours is written, an individual facade could exceed it by probably about 20 to 25%. And then if the average, I'm just thinking of those images we saw where those buildings on University Avenue, is that a 4-story or a 5-story, and how would you measure height? We still have that concern that we're lopping off extra stories, which seems to get us into difficulty with our comprehensive plan. I mean, the other issue is this is measured from the definition you're providing, Mark, is for each building, right? It's
each
based on the
facade.
building, not based on the parcel, each side of the building.
Okay. But the other thing that our code does allow, and this, you know, I thought about that, Kurt's, you know, if we've got a sloping site and we want to have, the roof doesn't necessarily have to be straight across that entire slope site, right? The roof, if the roof steps down, we have the building steps down, we can maintain the comprehensive plan's height all across that site. We don't actually have to lose a story. All we're doing is saying, hey, we don't want to add a story to the backside. We just want to maintain that height. That's really what is, you know, our zoning code allows.
Right?
So Mark, do you have a recommendation?
Well, my previous recommendation, you know, I liked it. So I don't, unless you want to see some changes, I felt that this was workable. I do suggest adding the established grade, but if you have concerns with my previous recommendation, then I guess I need direction as to what you want me to change. So that's why I didn't. I mean, I just was trying to answer your questions that you were asking for last time.
Yeah. One was responding to the email we'd gotten from Bill Connors about saying that would lop off
Well,
stories of building. And this does allow that the plan commission can make a determination as to what the building height actually is. So that gives us a little bit of that flexibility on the steeply sloped to make that determination.
Go ahead, Mark.
I would simply add what Commissioner Bruce said is exactly how I approach this as well. I mean, we went through this process. We overhauled our zoning code. We already have increased density pretty much everywhere, any commercial area or mixed use area in the city over what was previously there. We are familiar with at least one project and probably others that have slopes that could potentially cause some concern for adjoining property owners. We have step back provision to deal with that. But all that factored in together, you know, I do have the concern that, you know, the diagram that's in the map, that the Madison diagram does show, if you could scroll up, please, you know, that's as an example, that is, you know, that shows 4 additional stories exposed to the the left side, that is a significant, potentially significant impact, recognizing there still could be some step backs, but a step back is still going to be at a 45-degree angle, 1-to-1. So there's still going to be that height. What was the intent of when we overhauled the code? What our goals were to increase density, and we accomplished that. I'm kind of rambling here because I don't really know where else to go with this. So,
So establishing the grade is
I think having clarity, I think the code was very basic as it was written. The original language was the vertical distance from the established grade, and it didn't define established grade. So I felt that was important to add. It didn't specifically say it pertains to all four sides of the building. So I thought that would be good to add that clarity. If you can go back down to just a little bit, scroll, please. Yeah. So I felt like, okay, we're clarifying these things. There's obviously been some concern raised that we're not achieving as much potential density as perhaps we were intending, but my response to that is we've increased the density along all of our arterial streets. And west of the Beltline used to be limited, like west of Parmenter Street, the former Highway 12 used to be limited to 35 feet for height. And now we allow up to 10 stories. So,
And if someone has a property that really is impacted, they can bring us building designs and show it, and we could either do a PDD or consider changing the zoning ordinance at that time. But yeah, I think I'm satisfied.
can we override zoning on our,
Not usually, not without a
Zoning, public hearing.
public hearing.
I need a public hearing? Okay.
Another approach,
Never
I guess,
mind.
would be to increase heights by I won't say a story, but by X number of feet. In every district. That's, where do you draw that
Yeah.
line?
Or measure based on the front or the street facing side.
I don't want to make it overly complex. Because if I suggest this, George will have a lot of things to say, but I've seen ordinances where you get some marginal increase in average height for each additional foot of slope differential across a parcel, so that you would get something that looks like a flatter roof. But I'm not sure that would work in our narrow lots because we've got the step backs anyway. So this probably gets us solves 98% of our problems. And if there's such a unique parcel that you can't make it work in the ordinance, someone could apply for a variance or just do a planned unit development. And then that triggers the public hearing, so the neighbors can. Huh?
That triggers public hearings,
Yeah.
and that leads to higher costs for what ultimately is going to be developed there.
But I would say we would recommend this to council, and is the intent to just have a package of zoning ordinance amendments?
Yeah.
And do them all at once?
Yeah, that's been that is the.
But right now, if we don't have it, then, well, it's up to you as the zoning officer to determine what an application actually means in accordance to our current ordinance.
I've been doing that.
Yep.
So any other input, comments? So you got everything you need, Mark?
Well, so am I
I would-
hearing that?
I would make a motion that we recommend.
There's not a motion on the agenda.
Can we make a motion on this?
There's a recommendation
just
for feedback and guidance.
Recommendation for feedback, that
Providing
we
guidance.
provide guidance to staff that, item number 3 and number 4 here on building height as amended and established grade are
To incorporate those into the.
incorporate those in the,
Good to go.
good to go, incorporate those in the recommended ordinance changes. Wordsmithing a motion on the
Yeah.
fly is always,
Okay,
okay.
anything else? Anybody want to prolong the meeting?
Is that just a summary of the?
That was just a
consensus?
summary.
Yeah.
Okay, what's
You
the
got
motion?
it. We're not-
Wasn't a
we're
motion.
not
There you go.
voting. With that, I will close the meeting. Thank you all for attending.
Adjourned at 9:11 PM.
All right.
That was the height of discussion.